Assalamu alaikum, honorable person in the dais and on the of the dais. Indeed, a great honor to me, allowing me to say something before you. I am grateful to all of you, particularly Nadim Bhai. So, the topics given to me to say about the illegal process of declaring Indian citizens as foreigners. The lines indicates that what are the illegalities, how illegalities are committed in the process of determination of citizenship in Assam. The illegalities can be categorized in broad sense in two ways. Illegalities before trial, illegalities during trial. Before trial, I want to say that the illegalities during investigation conducted by the border police as well as the verification by the electoral registering authority. And this investigation stage, there are three categories of illegalities. In conducting the investigation, in making reference, and in taking cognizance of the case for trial. Then what is to be investigated? All these aspects are better understood when we refer some judgment. One judgment passed by the Honorable Supreme Court in Sarvananda Sonowal 1 case, and another judgment passed by Honorable Guwahati High Court in a division bench, that is State of Assam versus Muslim Mandal. In the Sarvananda Sonowal case, paragraph 60, Apex Court held that although burden of proof is on the suspected person under Section 9 of the Foreigners Act 1946, yet the state has initial burden to collect materials of doubt against any person. This indicates that there cannot be any reckless allegation. Doubt cannot be reckless. Before making reference, before doubting anyone, you have to collect, state is to collect materials of doubt. When the materials of doubt satisfied that this person can be foreigners or maybe foreigners, then only reference can be made against that person. Otherwise not. In paragraph 50 of that judgment, Supreme Court also said, reasonableness and fairness, unless reasonableness and fairness is adopted in the proceeding, the declaration is illegal. That reasonableness and fairness right from the beginning of the investigation till the final disposal of the case. In full bench judgment of the Guwahati High Court in the State of Assam versus Muslim Mandal, paragraph 97, 98 is very relevant. In paragraph 97, the Honorable Court has held that there cannot be any fair trial without fair investigation. And what is called fair investigation, that has been also explained. It means that the investigating authority must have to trace out the person, either by visiting his house or his workplace. And the suspected person should be given all opportunity to demonstrate that he is not a foreigner by producing his relevant documents at the investigation stage itself. That means during investigation, the suspected person has a right to defend the allegation. Unless that opportunity is given, there will be violation of fundamental rights under Article 14 and 21. So that opportunity, unless that opportunity at the investigation stage is given, there will not be fair investigation. And the person concerned has to be interrogated in presence of the elderly person of the locality. He is to be given opportunity to produce his documents in support of his citizenship. His statement is to be recorded, and after recording statements, his signature or thumb impression, whatever is possible, that may be taken. This guideline has been given by this full bench of the Honorable Guwahati High Court, ensuring that the investigating authorities should trace him out, to interrogate him, to ask documents from him, and if he fails to rebut the allegation, to counter the allegation, then only reference. Otherwise, the reference will be mechanical. That has been said in the next paragraph 98. The reference cannot be mechanical. Somebody is suspected, he is Bengali speaking person, so he is doubted as a Bangladeshi. So, allegation, so reference, that cannot be. That has been clarified in paragraph 98. The reference cannot be mechanical. And there has been a duty entrusted with the tribunal to look into the materials furnished by the investigating authority. Whether the investigating materials is suffice to form an opinion suspecting his persons, whether the investigating materials are sufficient to proceed the case. Unless there is no such materials, no main grounds of suspect, then proceedings should be dropped. No cognizance may be taken. But all these procedures, all this observation of the Supreme Court and the full bench of the High Courts are not followed by the tribunals. And the special division bench of the Guwahati High Court, which has been entrusted to take up the cases coming out from the tribunal, they are also ignored. Sometimes we find that the bench is led by a very good judge, and in that situation we get some good judgment. But not always. Our cloud, the people's cloud of citizenship is, citizenship of the people of Assam is clouded, and the sun rays are obstructed to reach the people. When there is no cloud, that means when there is good judge, then only possible to get the sun rays, the rays of the Almighty. Otherwise, the people are declared foreigners. So these are the part of the provisions as to how the illegality should be prevented in the investigation stage. But there is no law as to how the investigation is to be conducted. The Foreigners Tribunal's Order 1964 is the procedural law. But this procedural laws starts the proceeding and by issuing a notice with main grounds under clause 3 of the Foreigners Tribunal's Order 1964. This indicates that the notice may be issued with main grounds. That is the beginning of the proceeding. But what is main grounds? The law is silent. How the cases are coming out? On what basis the cases are coming out? The law is silent. Entire backgrounds of the case is not at all whispered under what manner the investigation is to be conducted and what basis the cases may be registered, taken cognizance, totally silent. And the question of fair investigation and fair verification by the border police and the electoral registering officer, the advocates are not allowed to question. You can raise any question about the investigation conducted before referring the case. You cannot question because the burden of proof is on the proceeding. You have to prove your citizenship. But the initial burden of the state, whereby the fundamental rights of the citizen, right to defend at the investigation stage, that has been denied. That has not been given to the victims. Because the fairness and fairness of the verification during investigation stage cannot be questioned. That is very important. And that can be done only by cross-examination of the prosecution witness, whether the police has traced out the person or not, police has given opportunity to him to furnish the documents or not. These questions are simply turned down, not allowed. Therefore, there is no way to check, to verify the correctness and fairness of the investigation. So this is one of the vital part of the proceeding, and because of that denial to raise question against the fairness of the investigation, fairness of the reference, that is a very vital part, and that has been denied in the process. And the tribunal always found blind in taking cognizance. Because in some cases we have seen the border police or the electoral registering officer, after verification, they furnish report that this person is found to be a citizen by birth, he has documents, so the proceeding may be closed. But tribunal never looks to that. Reference is given, so you face the trial. So you file your WS, furnish your evidence in chief, furnish your oral evidence. These are the way the tribunal used to function. Even the tribunal do not permit the advocates to look into the case records, do not issue certified copies of the inquiry reports. In a criminal proceeding, when a trial starts, after consideration of charge, or before that stage, in the consideration of charge, the court generally issued a set of investigation report to the accused, so that he can take proper defense in the trial. But in the foreigner's case in Assam, the tribunal never issued any copy of the investigation, never furnished what are the grounds of grounds to suspect the person. These are not furnished to the victims on the plea that burden of proof is on the proceeding. So you are to only prove the citizenship. You cannot go to the investigating materials. And the Foreigners Act 1946, there is serious defects. It's a law made by the Britishers to detect the foreigners like Japanese, Australian, French people, Spaniards, and those foreigners are floating, and that those people could be those foreigners could be identified by face. But this law has been applied to the people. They are not floating foreigners. And they cannot be identified by face because the face of the specific territory and the face of the people in Assam are almost same. And these people are living with the family members. They have entry in the voter list, land documents. They are not plotting foreigners like Japanese fancy see. So this law is also wrongly applied to these people. And my saying is that there is no methodology of identifying the suspected foreigners. So both the Basic Law of Foreigners Act 1946 is defective. The procedural law, the Foreigners Tribunals Order 1964 is also defective, not sufficient, providing sufficient way to defend the suspected persons. And the tribunal is to conduct the case in an arbitrary manner. What are the arbitrariness in the trial proceeding? I have already said that don't raise question about the investigation. And since the investigation are false, the reference based on false investigation, false verification, the reference particular contains wrong name. If a person is suspected and reference made in the name of Nuruddin, his voter list, his name is correctly written as Nur Ali. If he contested the case by documents as a Nur Ali, the tribunal used to say, oh, you said your name's Nuruddin before the investigation. Now we are furnishing the documents in the name of Nur Ali. So this Nur Ali cannot be, the documents of Nur Ali cannot be documents of Nuruddin. So your evidence, your documents are not trustworthy, not believable, so you are a foreigner. This way the tribunal is deciding the case. And if question is raised that the investigation report of the police or ERO cannot be an evidence under the CRPC also. Under the CRPC provision says that the statement recorded by the police cannot be an evidence. When the proceeding is suspected person adducing evidence based on his documents, that should be denied, that should be reported by the government pleader. That raising any objection to the evidence based on the investigation report, which is a false one, the evidence of the proceeding is disbelieved, discarded and declared foreigners. Admittedly, in the voter list, there are some mistakes. I used to write my name Abdur Rahman Sikdar, but in the voter list my name always coming Abdur Rahman Sikdar. I have made lot of pain to remove that defects. So that is my position. What will be about the illiterate people, the people who are every day they are fighting for livelihood, bread and butter. They are not at all concerned with the entry in the voter list and how the voter list are prepared. By sitting in one house in the one corner of the village, furnishing, names are furnished by other persons without personal hearing of the person. And therefore, there are lots of mistakes in the voter list, title mistakes, age wrongly entered. And picking up those mistakes, the evidence are disbelieved, people are declared foreigners. Can it be fair? Supreme Court in some cases has said the name discrepancy and shifting of residence cannot be ground to disbelief. That is not followed. In one case, of Guwahati High Court said that the village people, particularly the Muslim people, has variation of names. That variation cannot be a ground to disbelief. Another judgment by Justice Onima Hazarika, she also very beautifully explained that voter lists are not prepared by the voters, and any wrong entry in the voter list cannot be a ground to cause suffering to the voters. And that way, a precious most right of citizenship cannot be curtailed. But those are not followed by the tribunals. And these targeted people, they are mostly residing in the riverine area. And mighty Brahmaputra after 1950, its river bed become shallowed, and the water of the Brahmaputra river covered up very much area, eroding people, and many people shifted their resistance from one village to other, and taking the ground of shifting, the documents are discarded, saying that in 1966 your father was voter in village Y. Now in 1997 you are voter in village X. So how can we believe that your father in 1966 is your father? May not be also. It's doubtful, not trustworthy, not believable. So you are a foreigner. In the tribunal, the advocates, not only the litigants, but advocates are also terrorized. The advocates who are defending the people, they are also said, oh, you are defending the foreigners, so you are a foreigner. Advocates are also told that you are also foreigner. These are the words used by the tribunal against the lawyers. And there are so many judgments passed during the last 7 years, disbelieving the panchayat certificates, disbelieving the school certificates, disbelieving the Gauvra certificates. Gauvra means Gampradhan certificates. These are discarded, disbelief. And the ground of disbelief is that your certificate contains the state emblem. The panchayat secretary do not have the right to use the state emblem. The Gauvra has no right to use the state emblem. School headmaster have no right to use the state emblem. So these documents are invalid. So your evidence is also discarded. Your link has failed. So you are a foreigner. So these are the situation facing by the poor people of Assam. And I have already said the investigation. Investigation is so arbitrary. I want to cite one example of false investigation. You have heard the name, I think, the name of Sunaullah. He was an army officer. He was given a certificate of appreciation by the president also. And inquiry report, the border police termed him as a laborer, an illiterate laborer. On the day of inquiry, he was in Manipur, anti-insurgency operation. He was duty entrusted to him, and on the day of inquiry, he was in duty, and he was shown present in the house as a laborer, as an illiterate person. This is the case of a central employee of the central government, a defense personnel. What will be the case of the ordinary common people, illiterate people? That is the situation, and all these are creation. These cases are decided on pre-mindset, based on a narratives, and the narratives are, if you want to say narratives, the narratives are the judgment of the Sarvananda Sonowal 1 case, repealing the IMDT Act, the report of the Governor S.K. Sinha. In 1997, the Governor of S.K. Sinha was appointed as a Governor of Assam. He has submitted prepared a report and submitted to the Honorable President, alleging that the Lower Assam is flooded with Bangladeshi. And he also made observation that no misconception and mistaken notion of secularism should be in the way of declaring them as a foreigners, to curtail them as a citizen. He also proposed that these people are to be made stateless citizens without any political right, without any voting rights. He also made observation that because of these people, the Assamese culture and language in danger. In paragraph 4 of his report, he said that the report is prepared based on hearing of political leaders, journalists and retired employees. Can it be a public document prepared by that way? It is not a public document. It is a political document based on communalism. And that, unfortunately, that document has been accepted by the Supreme Court as a gospel truth. That is the basis of narratives. Everybody is heavily influenced by this judgment of the Supreme Court. He may be bureaucrats, he may be a judicial officer, he may be a police officer. So everybody are made a pre-mindset against these people. And the Supreme Court also observed, recording the report of the Governor S.K. Sinha, that the Assamese language, Assamese culture is in danger. Is it correct? If I am giving a picture, admittedly, there was a migration. But after partition, Muslims are expelled illegally by applying some deterrent laws like PIP scheme, like Foreigners Tribunals Order 1964, then Immigrant Expulsion Act. These are the deterrent laws applied to expel the Muslims, particularly from Assam. And nobody used to come, nobody dares to come back from to the Assam from this specific territory. Yes, there is one provision, one agreement between Nehru-Liaquat Pact, that is of 1950. Under this act, the Muslim people who fled Assam to East Pakistan out of fear to save their life, they were given a scope to come back, to return back to the India. And this law is also not taken note of. And in fact, the IMDT, the Assam Accord and the Section 6A, which is now under challenge before this Supreme Court. Section 6A has been introduced, has been inserted in the Citizenship Act, taking note of this fact. Indira Nehru-Liaquat Pact and Indira Mujib Agreement also in 1972. And these are also taken into consideration because of the constitutional provisions under Article 11, 253 and 51 also. So that law is now challenged before the Supreme Court. The Section 6A should be deleted. The foreigners should be, the cut-off date, year of the foreigners, detection of foreigners should be 51, not 71. I don't know. I hope that the Supreme Court will do justice, and if 51 is made, there will be a chaos. And most of the Muslim people have the NRC 1951, but that will also affect the other community. But in some area there is not available. The government could not conduct the NRC of 1951. So that is another part we are not so much concerned. Our apprehension is that the government is making a design to abandon the NRC, because the NRC have given protection. The allegation of large-scale unabated influx of Muslims into Assam, that has been proved to be false by the NRC. Despite all illegalities, arbitrariness adopted in the NRC process, 90% people of Lower Assam got entry in the NRC. So they are designed that 40 lakhs, 50 lakhs people will be deleted from the voter list, they may be made stateless citizen. That design has failed. So now they are making another planning how to harass these people. So NRC, they are likely to throw it to the dustbin, and the detection and determination by Foreigners Act and Foreigners Tribunals Order 1964, they want to operate full-fledged. By way of undue interpretation of documents, they can be declared foreigners. So these two milestones of the design, that is the Governor's Questionnaire Report and the Supreme Court judgment in Sarbananda Sonowal 1. But the conspiracy was made since long back. In 1978, the then Cabinet Union Minister, subsequently Atal Bihari Vajpayee became Prime Minister also. He made a speech in 1978 in the Parliament, saying that the huge number of foreign nationals got entry in the voter list in the northeast, particularly in Assam. Because of such speech, there was a huge resentment and reaction, and the effect of that reaction is that deletion of 40,000 people from the voter list in 1979 from Mongoldi constituency. There was another conspiracy, international conspiracy, that was done by American Pandit Myron Weiner. He published some writings. One is Project Brahmaputra Circular. He said that if the Brahmaputra river is controlled by multi-purpose project, who will be the beneficiary? They are not indigenous. Only the non-indigenous people will be benefited, because they are living on the riverine area, on the river banks of Brahmaputra. He also makes statement that because of these people, the Assamese language and culture will be in trouble. The Assamese culture and language may not exist. That was his allegation, and that writings were published in vernacular papers of Assam during the Assam movement. And those writings are the cards played by the agitationists. Those are the sources of building up the Assam agitation. But what is the reality? You will not find a single institution, academic school or college, in the language, in the medium other than the Assamese medium. All school and college are in Assamese medium, either Assamese medium, and nowadays some private institution in English medium. If they are pursuing here the Bengali language, then only can be termed that these people are threat to the Assamese language or culture. This is absolutely false, and these people, admittedly, our forefathers were origin of East Bengal. That was, my forefathers came to Assam in 1890. My father of my great-grandfather, he came to Assam in 1890. And he was not of anything. He was a Sufi. He he was a little antagonist to the of his father, because father was a landlord and harassing the ordinary common people. Bengal famine was there, and he contradicting with the father that I am not following your dictum to collect tax forcefully, and therefore he, as a Sufist, he went to Assam, and that way he stayed there. So these backgrounds are not considered at all. No Muslim came to Assam after partition. Rather, the Muslims were expelled by applying the deterrent laws. And these mindsets, not only in the citizenship, in all respects, the land policies are adopted. The riverine people are affected by the river, mighty Brahmaputra rivers, and they are mostly Muslims. But the land policy adopted only to give allotment or government land to the indigenous people. The Muslims are not treated as indigenous people. And therefore the eviction, the series of eviction in Assam, without any notice also, without any rehabilitation. So Assam that way become an epicenter of human rights violation. And the Muslims are targeted. But Assam was not that. It's a beautiful land where the Vaishnavite cult of Shankar Guru and the greatness, love, affection and nobility of Sufi saint Azan Fakir works together, and both the community, Hindu and Muslims, were united. And that heritage is badly damaged by the calculated and manipulated campaign of the communal force. And there was an instigation of the international force. Outside elements also worked there, made a campaign against the Muslims community. So these are the result of the hate campaign and conspiracy to de-establish the unity and amity, indignity of the people of Assam. But I think and I hope and expect that there will be victory. Ultimately, there will be victory of human rights. Human right will prevail over all this ill-design, all this conspiracy and hate campaign. With these few words, I want to conclude.